Hi everyone, welcome to Module 1, for which we have 32 questions for you on theft and related offences. Okay, here we go then. Question number 1. Where a person is caught shoplifting and the collective value of the goods stolen is £275, in accordance with Section 22A of the Magistrates Court Act 1980, which of the following statements is correct? Is it A, this figure represents a low-value shoplifting offence and will be tried summarily? Or is it answer B, this figure is not regarded as a low-value shoplifting and may be tried either way? And the answer is B. The threshold for a low-value shoplifting is £200 and will be heard summarily unless the alleged offender is over 18 years of age and elects Crown Court trial. However, in this instance, the collective value of goods stolen is £275 and therefore may be tried either way. Question 2. When dealing with the question of dishonesty under Section 2 of the Theft Act 1968, which of the following statements is correct? Is it answer A, a person's belief in law need not be reasonable so long as it is honestly held but cannot be based on a mistake? Or is it answer B, a person's belief in law need not be reasonable so long as it is honestly held and could be based on a mistake? And the answer is B, a person's belief in law need not be reasonable so long as it is honestly held and could be based on a mistake, including where that mistake is done on behalf of himself or herself or indeed a third person. Question 3. Where a person appropriates property for which there is a willingness to pay, which of the following statements is correct? Is it answer A, where such instances occur, the court may consider such an appropriation to be dishonest? Or is it B, where such instances occur, the court will consider such an appropriation to be dishonest? So is it a may or a will? And the answer is A, where such instances occur, the court may consider such an appropriation to be dishonest. Question 4. Where the provisions of Section 2 of the Theft Act 1968, those of law, consent or reasonable steps, do not apply, which of the following is correct with regard to the direction given by a judge to the jury? Is it A, this is an objective test according to the standards of ordinary decent people, that what was done was honest or dishonest? Or is it B, this is a subjective test based on the standards of ordinary decent people, and that the defendant had to understand such actions were honest or dishonest? And the answer is A, this is an objective test according to the standards of ordinary decent people, that what was done was honest or dishonest. Question 5. When considering the issue of appropriation in accordance with Section 3 of the Theft Act 1968, which of the following statements is correct? Is it A, there are instances where property can be dishonestly appropriated even though the owner has given consent or authority? Or is it answer B, when instances occur where the owner, by expression or implication, consents to property being taken, this will not amount to an appropriation? And the answer is A, there are instances where property can be dishonestly appropriated even though the owner has given consent or authority, such as, for example, where a carer takes advantage of a mentally vulnerable individual by cajoling that person into providing gifts, albeit under civil law, yet where the circumstances of the giving are dishonest. Question number 6. In recognising that property, in accordance with Section 4 of the Theft Act 1968, includes money, which of the following statements is correct? Is it A, the contents of a bank account can be stolen only when the account is in credit? Or is it answer B, the contents of a bank account can be stolen when the account is in credit or within the limits of an agreed overdraft? And the answer is B. The contents of a bank account can be stolen when the account is in credit or within the limits of an agreed overdraft. Similarly, reducing the credit balance of one account and transferring a like amount into the offender's personal account also amounts to an appropriation of property. Question 7. With regard to things growing wild, under which of the following circumstances will a theft of mushrooms growing in a field have taken place? Is it A, where a person at the time of picking has no sale, reward or commercial purpose in mind, then any later intention may not bring it under the provisions of this offence? Or is it B, where a person at the time of picking has no sale, reward or commercial purpose in mind, then any later intention will bring it under the provisions of this offence? And the answer is A. Where a person at the time of picking has no sale, reward or commercial purpose in mind, then any later intention may not bring it under the provisions of this offence. However, if the mushrooms, or indeed flowers, fruit or foliage, are being cultivated, it will be theft to pick them wherever they are growing. Question 8. Where Section 5 of the Theft Act 1968 refers to property belonging to another, namely those who have possession, control or a proprietary right or interest in the said property, which of the following statements is correct? Is it A, it matters not to whom the property belongs, merely that it belongs to someone other than the defendant? Or is it B, property must be shown to belong to someone in order for the defendant to be charged with this offence? And the answer is A, it matters not to whom the property belongs, merely that it belongs to someone other than the defendant. Question 9. When considering an intention of permanently depriving under Section 6 of the Theft Act 1968, which of the following statements is correct? Is it A, where the intention to permanently deprive is evident at the time of appropriation, returning the property at a later date will negate this offence? Or is it B, where the intention to permanently deprive is evident at the time of appropriation, returning the property at a later date will not affect this offence? And the answer is B, where the intention to permanently deprive is evident at the time of appropriation, returning the property at a later date will not affect this offence. Okay, then question number 10. Now we're going to do this slightly differently, so listen carefully. With regard to Section 8 of the Theft Act 1968, which, if either of the following scenarios, will amount to an offence of robbery? Is it A person enters a bookies and tells the cashier that if he doesn't hand over cash from the till, he'll shoot him with a gun that he has in his pocket. The cashier doesn't believe him and chases him out of the bookies. Or is it perhaps B, a person approaches the mother of a baby in a pushchair and tells her that if she doesn't hand over cash, he'll pour acid over the child's head. The mother screams and hands over the contents of her purse. So here's the twist. Is it A, option A, that's the bookies one? Is it B, option B, which is the lady with the pushchair? Or is it C, both amount to an offence of robbery? Or is it D, neither amount to an offence of robbery? And the answer is D. Now, despite the offender seeking to put the cashier in fear of being then and there subjected to force, as he or she didn't hand over the money, no theft, or steal I should say, has taken place and therefore no robbery has been committed. There was, however, an attempted robbery, so bear that in mind when you look at the options in the questions. Option B is also incorrect, because the baby could not have been put in fear of being subjected to force. But of course this may amount to blackmail. Question 11. When considering modes of trial for the offences of burglary under sections 9(1)A and B, which of the following statements is correct? Is it answer A, both offences will be triable on indictment if the ulterior offence is so triable, or if committed in a dwelling or non-dwelling and violence is used? Or is it B, both offences will be triable on indictment if the ulterior offence is so triable, or if committed in a dwelling and violence is used? So answer A includes non-dwellings, answer B does not. And the answer is B. Both offences will be triable on indictment if the ulterior offence is so triable, so for example as section 18 GBH with intent, or if committed in a dwelling and violence is used. So where violence is committed or used in a non-dwelling, such as a warehouse, then the mode of trial reverts back to being an either way offence. Question 12. In accordance with the offence of burglary under section 9(1)A of the Theft Act, in which of the following scenarios has the offender entered a building with the necessary intent? Is it A, entering the garage of a house as a trespasser, intending to take the car inside to impress his girlfriend, then dump it afterwards? Or is it B, having been dumped by his girlfriend, enters her flat as a trespasser while she is out, intending to wreck the place? And the answer is B. For the offence of section 9(1)A to be complete, the offender must enter the building with the intention to steal, do grievous bodily harm, or unlawful damage. And in this case, the offender entered the flat intending to wreck the place, hence unlawful damage. Answer A is incorrect because stealing for this section means an offence under section 1 of the Theft Act and not taking a conveyance under section 12. Nor does it apply to abstracting electricity under section 13. For example, he knew she was away on holiday and decided to turn on all the lights and electrical equipment to increase her utility bill. Question 13. In which of the following circumstances would a burglary under section 9 of the Theft Act 1968 be committed? Is it answer A, entering a house as a trespasser intending to rape the owner, or is it B, entering a house as a trespasser intending to steal, but finding the house empty, leaves having not taken anything? And the answer is B. R.V. Walkington, 1979, established that the intention of the offender is enough and it is immaterial whether there is anything in a building worth stealing. Answer A is incorrect, as rape is no longer an offence under section 9(1)A, having been replaced with the offence of trespass with intent to commit a relevant sexual offence under section 63 of the Sexual Offences Act 2003. Question 14. Section 9(1)B of the Theft Act 1968 relates to the actions of a person having entered a building or part of a building as a trespasser. In which of the following circumstances would the trespasser be guilty of burglary? Is it A, having hidden in the bar area of a pub until after closing time, when all quiet, grabs a bottle of scotch left on top of the bar, unlocks the front door and leaves the premises? Or is it answer B, having fallen asleep in the toilet of a pub, on waking, staggers sleepily into the bar area, picks up a bottle of scotch left on the top of the bar, unlocks the front door and leaves the premises? And the answer is B. Although the offender finds himself innocently in the toilets, having entered the bar area as a trespasser, he steals the scotch. A is therefore incorrect because although certainly guilty of theft, the defender did not actually enter the bar as a trespasser. He was already there. Question 15. In which of the following circumstances would the trespasser be guilty of burglary under section 9(1)B of the Theft Act 1968? Is it A, a trespasser looking for somewhere to sleep enters a first floor bedroom of a multi-occupied premises. Confronted by the occupant, a fight ensues where the trespasser unsuccessfully tries to push the occupant out of the window onto the street below? Or is it answer B? A trespasser looking for somewhere to sleep for the night enters a first floor bedroom window of a multi-occupied premises. Once inside, the trespasser is frustrated when the television doesn't work, so picks it up and smashes it on the floor. And the answer is A. Although neither case has any criminal intent upon entering the building as a trespasser, the trespasser nonetheless attempts to inflict GBH upon the occupier. And of course answer B is incorrect, as unlawful damage is not covered by section 9(1)(b). Question 16. When considering the mode of trial for aggravated burglary under section 10 of the Theft Act 1968, which of the following statements is correct? Is it A, aggravated burglary is triable either way? Or is it B, aggravated burglary is triable on indictment? And the answer is B. Aggravated burglary is triable only on indictment and carries a maximum sentence of life imprisonment. Question 17. When dealing with the offence of aggravated burglary, where one of two persons entering the premises as trespassers is carrying a weapon of offence, which of the following applies when considering a charge? Is it A, both persons will be charged with the offence unless the other person is unaware of the existence of the weapon? Or is it B, both persons will be charged with the offence regardless of whether the other person is unaware of the existence of the weapon? And the answer is A, both persons will be charged with the offence unless the other person is unaware of the existence of the weapon. Question 18. In which of the following circumstances would the offence of aggravated burglary have been committed? Is it A, trespasser enters a kitchen intending to steal and is disturbed by the occupier. Picking up a kitchen knife, he threatens the occupier that if he doesn't back off, he'll stab him. Or is it answer B, a trespasser enters a kitchen intending to steal and is disturbed by the occupier. Picking up a kitchen knife, he chases the occupier into the living room intending to stab him. And the answer is B. A person commits aggravated burglary if he commits a burglary 9(1)(a) or a 9(1)(b), and at the time has with him a weapon of offence. So in this instance, answer A is incorrect, because at the time of entering the kitchen, the person did not have with him a weapon, nor does he commit or attempt to commit GBH with the knife. However, having acquired the knife after entering the kitchen, otherwise known as instant arming, as soon as he chases the occupier into the living room, a part of a building with the weapon, intending to stab the occupier, he has committed the offence of aggravated burglary. And question 19. With regard to the offence of taking a conveyance without consent under section 12 of the Theft Act 1968, which of the following statements is correct? Is it A, this offence is triable either way and can be attempted? Or is it B, this offence is triable summarily and cannot be attempted? And the answer is B, this offence is triable summarily and cannot be attempted. Question 20. Which of the following statements correctly identifies the time limit for prosecuting an offence of taking a conveyance without the consent of the owner? Is it A, as this is a summary only offence, prosecution will be subject to a 6-month limit for prosecution from the time the offence was committed? Or is it B, despite being a summary offence, prosecutions will be brought at any time within 6 months of sufficient evidence to prosecute coming to the notice of the prosecutor? And the answer is B. As this is a summary only offence, prosecution will normally be subject to a 6-month limit for prosecution from the time the offence was committed. However, the Vehicles Crime Act of 2001 decreed that from the 1st of October 2001, prosecutions must be brought at any time within 6 months of sufficient evidence to prosecute coming to the notice of the prosecutor. Question 21. In which of the following circumstances will the offence of aggravated vehicle taking under Section 12A of the Theft Act 1968 apply? Is it A, driving the vehicle dangerously only on a road, or B, driving the vehicle dangerously on a road or other public place? And the answer is B. Dangerous driving of the vehicle may take place on a road or other public place. Question 22. Which of the following statements is true in relation to the offence of aggravated vehicle taking? Is it A, at any time after the vehicle was unlawfully taken and before it was recovered, an accident occurred by which injury was caused to any person? Or is it B, at any time after the vehicle was unlawfully taken and before it was recovered, an accident occurred by which injury was caused to any person other than the person in the vehicle? And the answer is A. The injury may be caused to any person. Question 23. A defence to the offence of aggravated vehicle taking will apply where the defendant proves the driving damage or injury occurred while neither on nor in the immediate vicinity of the vehicle. Now, which of the following statements is correct with regard to the term immediate vicinity? Is it A, immediate vicinity is a question of fact for the magistrate or jury to determine in each case, or is it B, immediate vicinity is defined as within a 50-metre radius of the driving damage or injury? And the answer is A. Immediate vicinity is a matter of fact for the magistrates or the jury to determine in each case. Question 24. Section 21 of the Theft Act 1968 creates the offence of blackmail. Now, in relation to the nature of the demand made by the offender, which of the following statements is true? Is it A, if the victim is particularly timid, this may be taken into account when assessing whether the defendant's conduct was menacing? Or is it B, the conduct of the defendant must be proved to have been likely to be menacing to a person of reasonable courage? And the answer is A. If the victim is particularly timid, this may be taken into account when assessing whether the defendant's conduct was menacing, provided the defendant was aware of this fact, so for example acting on a phobia. Answer B is incorrect, as the conduct requires that a person of normal stability and courage may be influenced or made apprehensive. Question 25. Where a defendant claims that a demand with menaces was reasonable and therefore not an offence of blackmail, on whom rests the burden of proof? Is it A, the prosecution, or B, the defendant? And the answer is A. If a defendant raises the issue that the demand was reasonable and proper, the prosecution must prove that the defendant did not genuinely believe that he had reasonable grounds for making the demand, and that the use of the particular menaces employed was not a proper means of reinforcing it. Question 26. When considering the offence of blackmail, and the defendant claims to have believed the demand with menaces was reasonable and a proper means of enforcing it, which of the following statements is correct? Is it A, the defendant's belief is subjective and therefore could be entirely unreasonable? Or is it B, the defendant's belief must be shown to be reasonable by the standards of a normal person of sound mind? And the answer is A. The defendant's belief will be a subjective one and therefore could be entirely unreasonable. However, if the threatened action would itself be unlawful, such as a threat to rape the victim, for example, then it is unlikely that the courts would accept any claim that the defendant believed the demand to be reasonable. Question 27. Handling stolen goods under Section 22 of the Theft Act 1968 requires which of the following states of mind when receiving stolen goods? Is it A, knowing or believing, or B, knowing, believing or suspecting? And the answer is A, knowing or believing the goods to be stolen. And the key here is that the goods were in fact stolen. So no theft, no handling. Question 28, and again, when considering the offence of handling stolen goods, which of the following statements is correct? Is it A, it will be necessary for the person responsible for the original theft to have been identified and convicted in order for the offence of handling stolen goods to be charged? Or is it B, a person can be convicted of handling stolen goods where the items were stolen outside of England and Wales, subject to the circumstances amounting to an offence in that country? And the answer is B. A person can be convicted of handling stolen goods where the items were stolen outside of England and Wales, subject to the circumstances amounting to an offence in that country. And therefore it will not be necessary for the person responsible for the original theft to have been identified and convicted in order for the offence of handling stolen goods to be charged. Question 29. Where a wrongful credit to an account has been derived from an offence of blackmail and subsequently wrongfully retained, will any subsequent dishonest withdrawal of that money from the account be considered as stolen goods for the purposes of Section 24(4) of the Theft Act 1968? So is it answer A, yes, on the basis that such wrongful credits can be derived from the offence of blackmail? Or is it answer B, no, on the basis that such wrongful credits cannot be derived from the offence of blackmail? And the answer is A, a credit to an account is wrongful to the extent that it can be derived from theft, blackmail or fraud under Section 1 of the Fraud Act and is therefore classified as stolen goods. Okay, now for the purposes of the last three questions in this section, they will be for promotion candidates only, as they relate to the offence of going acquit for stealing. So question 30 then. In accordance with Section 25 of the Theft Act 1968, going acquit for stealing, which of the following statements is correct? Is it A, the article will be for use in the course of or in connection with any burglary, theft or cheat? Or is it answer B, the article will be for use in the course of or in connection with any burglary or theft? And the answer is B, the article will be for use in the course of or in connection with any burglary or theft, cheat having been superseded by the Fraud Act's offence of possession or control of articles for use in fraud. And question 31, which of the following statements is correct with regard to the offence of going acquit for stealing? Is it A, this offence applies to a person in possession of the article, whether it be for that person's use or another? Or is it B, this offence only applies to the person in possession of the article and not for use by another? And the answer is A. It is not necessary to prove that the person in possession of the article intended to use it, merely they had possession of it for use by someone. And lastly, question 32. When referring to a person's place of abode under Section 25 of the Theft Act, going acquit for stealing, which of the following statements is correct? Is it A, if a person lives in a vehicle, then it is regarded as their place of abode, irrespective of where it is parked? Or is it B? If a person lives in a vehicle, then it is only regarded as their place of abode if it is parked in the place where the person abides or intends to abide. And the answer is B. If a person lives in a vehicle, then it is only regarded as their place of abode if it is parked in the place where the person abides or intends to abide. If a person is found with articles in the vehicle away from its normal site or location, then this offence is committed. Well, I hope you found these questions useful, and if you did, then please take a moment to subscribe to the channel, maybe even spread the word. And if you'd like to know more about the handbooks, then look me up at amazon.co.uk to see if this is the style of learning which can help you with your ongoing studies.